Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me as always is my co-host, Senior Associate from MBK Chapman, Sam Kill. Sam, good morning.
Morning, Mike. How are you today?
I'm fine, thanks. So Sam, as you know, today we're going to discuss what I think we both agree is the most common form of abuse that we see at bad HOAs in California and probably HOAs throughout the country, and that is selective enforcement. Okay? And before we dive in and define selective enforcement, I'm going to start with a story. I'm going to start with an example of it because I think it's a great example of selective enforcement. And more importantly, this is actually one that I highlighted as a case study in chapter 12 of my book, HOA Hell, California Homeowners Definitive Guide to Beating Bad HOAs. And this book is already, it's in pre-order right now. It's already a number one bestseller on Amazon for real estate, self-help, and law books. The reason is because I think it's worth it. But we did an episode, podcast episode last week, and it's already available in our collection of podcasts on the new book. So I urge you guys to watch that so you can get a look at what's in the book. But today we're going to talk about selective enforcement. So let me just jump right in because selective enforcement is, although it's the most common form of bad HOA abuse, it is a quiet form of abuse. It is. Okay? And it is a way for boards, or particularly bad board members, to reward friends and allies and punish people they don't like or people that they deem to be troublemakers or as a means of retaliation. It all runs the gamut, okay? And it often, what's pernicious about selective enforcement is it often looks very innocent on the surface. But it's not innocent. It is extremely destructive, and we'll talk about why toward the end of the episode. So let's get right into this case, okay? I talk about this case in my book, as I said a minute ago. Now, this client was in the middle of a massive and approved renovation of his yard, okay? This is a community in San Diego. There are a couple hundred homes in the community. And this is important I'll explain why later, but it's an upper end community. The houses are anywhere from 4 to 6 or 7 million. It's I don't know now. I looked a few years ago, so it's probably gone up. But these are very high end homes, okay? This particular homeowner, client of ours, was in the midst of a complete redo renovation of the entire yard, including the construction of an ADU, which I've since seen is beautiful. It's pretty cool, actually. And all that had been approved. But during construction, this client of ours decided that he wanted to give his wife, who is got a green thumb, who loves plants, he wanted to give her a beautiful greenhouse. So he decided to build a beautiful greenhouse. And he didn't feel like getting permission from the HOA and going through all that. So he just built it. While his contractor was there, for the several months that the contractor was there, they built this permanent structure. And I say permanent because this thing had a cement footing. It was in there. It was wired. It was made of both glass and wood. It's actually gorgeous. Okay. Now, this HOA, one of the rules in this HOA, they had specific setback requirements that applied both to the sides of people's properties and then the front and the rears. So this thing was applying to the side. And this greenhouse was built squarely within the setback, meaning there was an absolute violation of both the CC&Rs and the architectural guidelines for this community. I don't know, I can't recall at this point whether my client knew that it was within the setback or whether he even knew the setback was an issue or not. But I do know that there was no debate. This thing was literally in the middle of the setback, which was prohibited. Language was well written, was plain English. There was no dispute. Okay? That's important because when our clients are in the wrong about something, we tell them. And I did tell them. So, of course, with the HOA president in doing she and a couple of cronies from the board very much dislike this client. And the reason they dislike this client is this client speaks his mind at meetings. He goes to meetings and he speaks his mind when he thinks something is being done wrong. And this particular lady, who is the president of the HOA, instead of taking it as just criticism and maybe listening to what the homeowner is saying, took it as a personal attack on her. And we've talked about people like that. People like that shouldn't be on boards because if they take everything as a personal attack, that says something more about them.
You like the temperament, yeah.
Exactly. But the point is that she had and a couple of her cronies on the board had a dislike for this homeowner. And during the inspection of his property, noted the greenhouse. And of course, they called him out on it. And they were, in this case, correct to do that. Correct in the sense that they were correct that he'd violated the governing documents. He didn't apply for it, and it was within the setback. They also argued that it was a shed.
Oh.
Now, they're wrong about that, and we'll talk about that in a minute. And this example is, reason I'm going to spend time on this example is because it is classic selective enforcement, okay? So anyway, the board president made an impassioned argument to the board as to why this needed to be stopped, and he got the typical letter, take it down immediately, blah, blah, blah. Now, again, this thing was a permanent structure. It had been wired, it had been footed, everything was underground. This was expensive. So this was I think I said in the book it was $75,000. It could have been $7,500,000 structure, but whatever it was not something that the homeowner, our client, was willing to take down. So he immediately applied for, sought a variance. They denied the variance. They didn't even he technically had a right to be heard, but it was a foregone conclusion. Okay, it took him 30 seconds to deny the variance. Now, that's when the client came to us. I took a look at everything. And by the way, this client has been, for reasons I won't go into, this client has been a client for many, many years. So I decided to handle this one personally. This client was willing to spend the money to do that and wanted me to do it personally. And this is one of the few cases that, I had time at the time. So I said, I'll take care of it. Okay. So first thing I did was I looked through the governing documents and I had a conversation with my client and said, well, just FYI, you're dead wrong here. You have absolutely violated, the application rule, okay, big deal. You didn't do the application. It's required. You didn't do it. That's one thing, but you're within the setback. There's no dispute. I think the setback for the sides was 10 feet and he was, 4 feet in, 6 feet from the wall. I mean, there's no dispute. Yeah. Okay. But then I said, well, it doesn't mean it's the end of the road. Let me do a couple things. So I have some, when I need somebody to fly a drone, I have some teenagers that I employ as drone consultants for me who are very good at, the remote control stuff. And I hired this teenager to go into the neighborhood, or actually did from outside the neighborhood, but to fly a drone over all couple 100, 300, whatever homes in the neighborhood. 150, 200 feet up, fly around, okay? Take pictures and video. Then I took a look at the photographs and I noticed something. Lots and lots of the properties had permanent structures built in the setback. Barbecue pits, barbecues, fire pits, pergolas, play structures, and sheds, temporary and permanent. And I wasn't talking about just 2 or 3 or 4 homes, dozens. What I took particular interest in was that the president of the HOA's home had 3 separate structures that all violated that exact same rule, the setback. She had a pergola, she had a barbecue, like a built-in barbecue with the whole kit and caboodle, and a fire pit, all within that 10-foot setback.
Nice.
So in fact, what I was really happy to see was that even the president of the HOA, the one spearheading this entire effort against my client, had violating structures. Not one of those owners, because we had documents, we didn't have to do a 5200, we had plenty of documents. Not one of those homeowners had ever sought permission to build in there. They just did it. They'd never been fined. There was no evidence of any fines. It was clear that the board was singling out our client. More importantly, even if they had been approved, and some maybe were, that still would qualify, right? Because they aren't approving my client.
Correct.
So I wrote a letter. It turned out to be a 17-page demand letter. And I started out by acknowledging right at the front that my client's structure, the greenhouse, violated the governing documents. And I cited the governing document that was in violation. I acknowledged in different words than this, but my client does not dispute, in fact admits that their greenhouse, because it was a couple, but I'm saying his greenhouse absolutely violates section whatever of the CC&Rs and the architectural rules. So we acknowledge that. It does not constitute a shed, and I gave reasons why. And I went and I found multiple definitions in the industry, California real estate industry, multiple definition of sheds, none of which applied at all. Okay? And then, after that, I spent several of those 17 pages detailing pictures of maybe a dozen of the different properties. I started, of course, with the president's house. Zoomed in beautifully, okay? Identifying in each picture what the address was.
Nice.
And then identifying the violating structures, all of which were setback and or sheds. And I, of course, spent a little more detail with the president's house. I dropped her name, in fact, okay? And I explained that the HOA's explicit or tacit approval of the dozens of similar violations presented a very big problem for this HOA. If they decided to continue trying to enforce those governing documents, which were valid, against my client and nobody else. I also explained that if they intended on enforcing, we would make sure that they enforced against everybody, which would have amounted to millions of dollars in reconstruction for dozens of homes. If you add up the money that it would have taken to tear all that down.
Not to mention legal fees, disputes.
That's right.
Yep.
And we would, of course, make sure that everybody knew that it was because she and her two cronies on the board, which made up that majority, right, didn't want to grant the variance. So I happen to be dealing with one of the big law firms that we always talk about on the other side. And that law firm, the lawyer handling it, was one of those lawyers that we talk about on the other side who was quite reasonable. And I say that because the lawyer didn't just take a position because it benefited their client. He looked at this thing objectively and acknowledged, we got a problem here. And it was not difficult to reach an agreement with the HOA. HOA required my client to plant 2 or 3 trees that would, within a few months, grow enough to block whatever view might have been visible from the yard of the neighbor, even though the neighbor wasn't against it. No problem. In return, my client got all of the attorney's fees and got the variance.
Beautiful.
Okay?
Yeah.
I would call that the perfect result. Now,
you turned a losing hand into a victory.
Exactly.
Yeah.
And the reason this particular story, not in the same detail, but it is highlighted in chapter 12 of the book, is because chapter 12 is where I talk about stacking and layering and creating leverage. Now, this story is a perfect example of selective enforcement. So let's talk about for a minute what selective enforcement is. Most simply, selective enforcement is when an HOA applies its rules unevenly.
Unevenly, yeah. Inconsistently, too.
Inconsistently, okay? You penalize one homeowner for doing something that other homeowners do without reprisal at all, okay? You focus on one homeowner and overlook other similarly situated homeowners.
Right.
You can say it in a variety of ways, but that's the basics of what this is. That's what we're talking about, okay? And it shows up in every area of HOA life. Do you have any examples off the top of your head from any of your cases of selective enforcement?
Countless. Here are a few.
Give me a couple, and I'll give
One
a couple.
is, let's say, holiday lighting. 2 similarly situated homeowners, apples to apples. They both have, Christmas holiday lighting up. One gets a notice to appear at a hearing and is ultimately fined. The other, nothing.
Right.
And
For keeping them up too long. Is that where you're going?
For keeping them too long, exactly, exceeding what's clearly articulated in their rules and their operating rules. And in this case, this client happened to know the neighbor very closely. They were friends. And so he was well aware that they were not receiving any, enforcement-related
and both sets of lights were still up.
Exactly.
Right.
Exactly.
So in this case, let's say the CC&Rs, I don't know, I don't recognize the fact pattern, but let's say in the case you're talking about, the rules were, you put Christmas lights on the week after Thanksgiving, they have to come down by January 6th. Let's say that was the rule. I'm just making up a date, okay?
Yeah.
January 8th, our client got a letter, but the next door, a good friend who still had lights up too, didn't get the letter.
Correct.
And by the way, didn't get the letter in the next week or the week after that either. It wasn't like it was coming. It just never arrived, right? Okay, good one. That's a great one.
Here's another one just yesterday, a PC consultation, meaning a potential client. So this was a consultation, and I think they will retain. They have overgrown front lawn by just a few inches.
Okay.
And they've actually taken a ruler to it, measured it, they produced photographs, which is fantastic. And so does their neighbor. Their neighbors actually, they've been more derelict in maintaining their front lawn. And this is not their immediate neighbor, but a few homes down, same street, within the purview and jurisdiction of the same association. And they get a letter, and the neighbor, nothing to their knowledge. So same thing. Again, apples to apples. And what they did is they captured photos, they presented it to us, and I said, look, it's prima facie on its face that this appears to be uneven and consistent treatment. You're possibly being targeted, and there's more to it, and I'm sparing.
Right. And I'm sure there was other. I'm sure this person could have gone around the neighborhood and taken pictures of other overgrown bushes or overgrown.
Correct.
Apples to apples is whether it's grass or bushes or flowers or whatever. It would be the same thing.
Right.
Okay. Here's one. Those are two good ones. We see those all the time. Paint color. I submit a paint color within a certain spectrum. Okay. Let's say your HOA isn't one of the ones that literally gives the hex code, right, for the paint color, but gives a spectrum of colors. You pick one that is maybe not from the same company, so it doesn't have the same spectrum name, but it's the same shade, right? Yours is denied. Somebody else from a different company using a different, Dunn Edwards versus Sherman-Williams, their paint color is very similar to the one you did. It just has the different name, and that's accepted. Okay, we've seen that a lot as well. Or you submit plans for a patio cover. You want to have, you want to take your pergola, which, rain comes through the pergola, right? You want to go and cover that and weatherproof it so you can stick a TV or a fan out there or whatever, and that's denied. But darn well there's other people in the neighborhood that have covered pergolas, right? Or you receive a hearing because your dog has been making too much noise, and yet you hear dogs all the time, and they never get in trouble.
Yeah.
Ever, ever, ever. And in fact, that's been a point of complaint because you yourself have complained. And as far as no discipline's ever been done, but your dog, barks or creates some noise. And again, barking dogs, if it's sufficient, is a nuisance. Selective enforcement only matters when there's actual violation of the rules. The issue isn't that I didn't violate the rule and I shouldn't be in trouble. The issue is you're punishing me for violating the same rule that everybody else gets to violate, and you don't punish them. That's the issue.
On that example of the dog one, that's fantastic because you've put them on notice. You complained, so you know for a fact that they have knowledge of the issue with someone else.
Exactly.
Yet they enforce against you and have
exempted
them.
Now, California courts, there's no statute. There's nothing in the Davis-Sterling Act that says thou shalt not commit selective enforcement.
Right.
Okay, that doesn't even appear in the statute.
No. But
there is a statutory basis for the prohibition of selective enforcement.
4350.
And it talks about reasonableness, and it talks about all the rules that we've talked about, 4350 being one of them. When it comes to HOA rules, they have to be applied uniformly. They can't be, and this was more 4675 architectural, but it's case law said it applies to 4350. You can't be arbitrary and capricious in your following of the rules. You can't favor one over another. That's another way of saying you can't selectively enforce.
4765, presents.
Did I say 4675?
Yeah. And you meant the right one. But basically provides a good faith. So the boards need to actually review and make decisions based on good faith and not arbitrarily and capriciously.
They have to be fair.
Absolutely. 100%.
Fairness is a big part of how our system is supposed to work. Rules are supposed to be applied uniformly across lines when you're dealing with apples to apples. Okay? Now, California courts interpret the sections we've been talking about to mean that rules are only valid if they're enforced the same way for everyone. You can't have a rule and stand on that rule if you only apply it to these people over here but not to these people, assuming that the rule applies to everybody.
Right.
Now, I'm not talking about situations where there's a rule that would only apply by its very nature to a condo and not to a single family home. And if your association has a mix, then a rule that could only apply to a condo, like an upstairs walkway or staircase, well, the single family homes aren't going to even have those. So if there's a rule about a staircase, it's going to only be applied to the condo people.
That's different. That's not selective enforcement.
We're not talking about that. We're talking about apples to apples. Okay. So how do you recognize selective enforcement? Well, it's actually easy. Okay? You ask yourself 3 questions. All right, question 1, have other homeowners done the same thing that I'm doing or being accused of doing and without penalty? It's a very simple question to ask, okay? Did a board member or a board member's friend or relative receive approval for something that I was denied approval for? Okay? Now, these questions overlap. You could overlap these, but
yeah, it's a good test.
It's a good test.
Yeah.
And then third is, are the violations are violations that I'm being accused of violating only enforced when one or more certain directors do the complaining? In other words, are there people on the board that spearhead the select enforcement, and the other board members either cowed or otherwise just go along with it? In other words, they wouldn't care, live and let live. But when these people bring it up, and they're always the ones that bring it up, that doesn't always mean it's selective enforcement, but that is a red flag.
It is.
So those 3 questions, okay, any one of those could yield the answer you're looking for.
Yeah.
Okay, so if the answer is yes to any of those questions, then you're probably looking at selective enforcement. I'm sure there are exceptions, but I'll go with that. The telltale sign can be drawn down to one word: inconsistency. You agree?
Absolutely.
Okay.
Yep.
HOAs that genuinely enforce valid rules consistently will always be able to prove it from the record. Always. Even if it's now, it doesn't mean homeowners get to see that record. For example, minutes that are taken in executive session are not available to homeowners. But overview of those minutes are, because they're supposed to be described in the open meeting minutes as to what was discussed, leaving out certain privacy details. So to the extent that there's a hearing, a disciplinary hearing that occurred within the scope of an executive session, I, as another homeowner, would not be able to do a 5200 demand and get the minutes from that executive session. I could get it during the course of a lawsuit in discovery, but not under 5200,
right,
and not pre-lawsuit. But I would know that I should be able to tell from the main minutes that there was a disciplinary hearing regarding violation of the, grass rule or violation of the trash can rule or whatever.
Yeah.
I should be able to see that much without seeing the name. Okay. Good HOAs that apply rules consistently always can prove it from the record. Bad HOAs always have an excuse as to why it's not in the record.
Right.
And if it's not in the record, you're dealing with a bad HOA because there's no 2 ways about it. Okay.
At best, that would be a massive red flag. At best, but what it truly is, though, and oftentimes the eye test will answer that. Let's just say an HOA of 100 homes, and you have 50 homes that are pretty much in violation for substantially the same thing you've been cited for, and that has persisted for a long time.
Just like our client in that example at the beginning.
And just the eye test or just the gut feeling oftentimes tells you, wait, what? I got this for my recreational vehicle, yet all my neighbors have some version of that, and they've.
I bought a Sprinter van, and they're saying no, but Bob, Billy, Mary Ann, and Samantha all have Sprinter vans, and they've had them longer than me.
Yeah, what's going on?
Yeah, exactly. And by the way, if the HOA, look, there are in some cases there are arguments on both sides as to an HOA granting a variance in one specific case, and there are reasons an HOA can grant variances for one and not another. One example isn't going to be enough to prove selective enforcement. If you're seeking permission for something and there's 1 or 2 out there and that's it, it's probably not a good case by itself. There's got to be multiple.
Or in your case, I mean, you gave a great example with the dog one where you specifically complained, but in your case, you have a neighbor, perhaps a bad neighbor, who's nosy, watching you with binoculars.
Or hyper vigilant.
Right, and they're constantly complaining, pestering the board. So you are on the receiving end of enforcement. But let's say one other example, way down the street, they're not dealing with the same neighbor, and so the board may not be on notice of it.
Except
perhaps,
if you're the one that put them on notice.
Unless you put them on notice of it.
Right. So why do boards engage in selective enforcement? Okay, because that's it seems like a psychological question, but it's not. If you understand why, it also helps recognize when.
Yeah.
Okay, selective enforcement is rarely, and I think I get this from experience, is rarely about the rule itself. It's almost always about power, whether it's consolidating power, holding power, or exercising power.
That's a good point. Yeah.
Okay. Bad boards enforce rules on their critics and ignore their friends to create fear, to create compliance, and it keeps owners off balance. And it solidifies control. Those are just facts. Okay. But selective enforcement isn't just unfair. okay? It erodes trust. And I'm using quotes here, scare quotes. It erodes the rule of law or the rules of rules.
Right.
Okay, because it undermines the entire foundation upon which the HOA is supposed to be built. A mutually agreed upon set of rules. We all bought in this community having been given copies of our governing documents beforehand. Presumably you're tasked with having read them, and you, by finishing the purchase, agreed.
Right.
And that's how the law sees it, right? So when decisions are motivated by ego instead of the law, or by power, which I guess would be ego as well, right? The board's actions become legally indefensible.
And it becomes virtually impossible to expect what that standard is, when it will be applied, when it'll be given a pass.
Right.
That's problematic.
So to make things just really simple, bad boards engage in selective enforcement for power, fed by ego. That's the answer to that. And whether
or animus, right?
Well, but that's ego.
I guess,
ego.
yeah, sure.
Okay. They use it as a means of retaliation for people that attack them, seemingly attack them or complain about how they're doing things, whether accurate or not.
Yeah.
They use it as a means of consolidating power because they enjoy the power. They enjoy what it makes them feel like. They selectively enforce to reward people that they like, not necessarily to punish people they don't like, although it often goes hand in hand, but to reward.
Yeah.
It doesn't matter why. It's still pernicious, and it still erodes. And you can't be tolerated.
Or they have weak temperaments, and just the human condition is one where allies get rewarded, and then you target the ones, let's say, for instance, a group of homeowners seeking to remove you or question you or hold you to account.
Exactly.
Yeah.
So it's not enough for us to talk about what it is and why it exists. A lot of you might have already known that. This podcast likes to go a lot further than that. This podcast likes to answer the question, okay, how do I fix it? What do I do about it? So we're going to answer that, okay? Number one, if you suspect that you are a victim of selective enforcement and it is rampant, okay? We have 55,000 HOAs in California and counting with God knows how many members for each of those. We're talking millions of people, okay? Number one, start by documenting the selective enforcement. What that means is take clear, dated video and photos, although you can get photos from video too, but I guess, so either way, of other properties in your HOA. That's pretty important, okay? With the same conditions or improvements or violations, whatever the issue happens to be.
Yeah.
If your issue is you've made you're not in violation of any rule, you're just seeking an application to build a closed pergola and they deny it, but you've got 5, 6, 10, 15 other people in the community that have those, go get video and pictures of those, okay? Take dates, okay? Make sure the photographs are dated. Often that's easy to do with metadata, but whatever, just make sure you do that. If you've been cited for a violation, go find other people that have violated the same thing and not been cited. Often you can approach a neighbor and talk to them and say, hey, they cited me for this. Have you ever been cited for this? You don't have to say, I notice you are in violation. Why haven't you been cited? You don't do it that way. That's not a smart way to do it. But you might ask them, hey, I'm getting cited for this. Has the HOA ever gone after you? Because we should change the rule. This should be allowed, you know? So that's kind of a backdoor way to get that information. Or if you just happen to know that the other person has been cited, video and picture, okay? Don't trespass on somebody else's property.
Yeah.
Okay. But I don't have a problem with you taking a still photo. I wouldn't video if you're going over somebody's fence, but if somebody's got a shed and it can't be seen from the street and you want to put the camera up over the gate, I don't have a problem with that as long as they're not out there sunbathing. Take the picture. I don't care. So document. Very important. Write down their addresses. If you know the names, associate the names with the address. Addresses are sufficient though. Okay. Next, once that's done and you've got for example, in my case, once I had all that drone footage and photographs, dozens and dozens of photos, okay, exercise your rights under 5200 of the Civil Code. We've had multiple episodes in this podcast where we talk about the power of 5200. My entire chapter 4 of this book is dedicated to the power of 5200. So do a $5,200 request for certain documents. You want board and committee meeting minutes, right? You want record approval, denials. You want general descriptions in the open minutes of violation hearings. You're not going to get the details. Again, that's executive session. There's privacy issues at work there. But you're entitled to the records, at least as to the basic nature of what was discussed in executive session. And as a homeowner, you're entitled to those documents. Okay? If the association refuses or says the records don't exist, either way, it not only strengthens your case, but in that it's very likely that they're hiding multiple instances of selective enforcement, but it also helps build leverage because you've got a second violation, because violating 5200 is its own problematic wrong that they can actually be fined for. And it's a toothy fine. Again, I won't go into it in this episode. We've already taken care of that elsewhere. Next, under 4765, check whether the board followed procedure with those other properties and with your property. For example, let's say I submit my plans to my HOA.
Yeah.
Okay. They deny my plans. They deny my pergola. Okay. What has to be part of that denial?
An explanation detailing the basis for that denial and if there's an opportunity to cure or adjust in order to get it passed and approved, then state that.
Yeah. So they have to give you the reason of the denial. If the reason is based on a rule, they have to cite that rule. If it's based on a provision of the CC&Rs or any other governing document, they have to cite that provision. So, for example, let's say you were seeking to build a greenhouse within the setback. In their denial, they got to say your greenhouse is denied as currently applied for because it's within the 10-foot setback, which is set forth in Rule 2.37 of our rules, which implicitly, even if they don't say it outright, says if you were to move that somewhere, we might consider it. They should say that.
And by the way, that also factors into the good faith aspect under 4765.
That's right.
Which is, if you're operating from a standpoint of good faith, you're not preoccupied with a flat-out unconditional denial with no opportunity to correct, cure, or get it passed.
Exactly.
You're saying, hey, my fellow, member in this community would like to do this. They have a right to do it so long as it's copacetic and complies.
Exactly. But as currently applied, they're within the setback, so we need to let them know that. But also let them know, look, if you move that, if you have space over here, then we would probably approve it. But because you're in the setback, we can't. That would be the appropriate way to handle it. Of course, unless, of course, dozens and dozens of other properties have stuff in the setback, and then we have a different issue, which is what we talked about at the beginning. But here's the bottom line. If they don't cite the basis of their denial, or if they do cite the basis, but it's not grounded in any actual written rule, it's just an aesthetic thing. We don't feel that it matches the aesthetics. That ain't good enough.
It's not.
Okay? That strengthens your case.
And then that also makes the odds of it being arbitrary and capricious far more likely, far more probable.
And once you have your evidence, once you have your evidence in the form of the pictures and maybe some documents, and by the way, pictures might be enough. In our case, we had multiple documents, but I didn't need them. The pictures were more than I needed. So I ended the inquiry there. Okay? But once you have whatever evidence you've gathered, whether it be videos, pictures, and or governing documents, or minutes or whatever, once you've got all that, send a very professional, nice, objective email to the management company, the architectural committee, if one exists, and to all members of the board, saying, okay, I'm who I am. Here's my address. As you know, I recently applied for, or as you know, you recently sent me a letter calling me to a hearing for XYZ, or whatever the situation is. Detail the situation. Say, acknowledge whether or not what you're seeking is or isn't within the rules. It's okay. It's not like it's okay to show that hand. It is or it isn't. All right? If it's written in there, it either is or it isn't a violation. If it is, acknowledge. But then say, however, I happen to know that 37 other homes in our community have the exact same thing, and they were either approved or have not been demanded to take it down and or disciplined for having that same thing. That is not legal. Here's my proof. And you submit it and say, therefore, I'm asking you to reconsider and grant me a variance or withdraw your complaint or whatever it is that's at issue. If they say no, that's when you come to us at MBK Chapman. That's when we get involved. But if they say yes, great.
Yeah.
They wouldn't say yes if you just demanded, well, wait a minute, we want you to change your mind. You got to give them a reason to change their minds. You got to show them where they screwed up. Okay? You want to add anything?
Just one thing that comes to mind, because I saw some success with this approach. I had a client, and we've since resolved their matter rather successfully. They basically acknowledged that there may be confidentiality considerations on the board's end in terms of not divulging a lot of details about other enforcement, whether they're at ADR stage or notice and hearing
That's fair.
phase. And they said, look, I'm not looking for you to disclose all of that to me at this stage, but something is fishy. Something seems off. Can you just tell me how many similar matters you have ongoing or you've had recently, and
Exactly.
how many and just give me some statistics, give me some numbers. And sure enough, in this case, the association cited, we have, I don't recall the details off the top of my head, but something to the effect of, we have this many number of cases, this many of them agreed to comply voluntarily, this many of them, without divulging or naming names, we are in the process at various phases of pursuing it. Now, they had multiple issues with us, so they still engaged our firm, became active clients. We pursued some of those, but as to that, they were happy enough to just kind of let it
Fair enough.
let it
I
go.
accept that.
Yeah.
All right, so until you brought that up, I actually had completely forgotten that there was a part of this client's case, the one I talked about at the beginning, that related exactly to that.
Oh.
I had asked, we brought up a second issue after we kind of resolved this. Okay. We brought up a second issue with a neighbor relating to a neighbor's hobby, and the hobby of the neighbor absolutely violated several provisions of the rules, including had a professional car lift.
Oh, okay. Wow.
Because this person had a love and affinity for really old muscle cars, like from the 50s and 60s, and routinely had several on the property and had gasoline cans and chemicals and the lift where he'd lift the car, right? And there were several issues. And the rules and the architectural guidelines were very clear. You cannot fix your car anywhere within the community at all. You can do no repairs to a car. You certainly can't store old cars that are not in working order, all that stuff. Complete violations. We brought that up, okay? I said, look, I don't need you to tell me what you guys are doing or not doing to this neighbor. I just need to know whether or not you are investigating the complaint or not. And if you do investigate it, are you going to follow the governing documents? I don't need any specifics.
Okay.
And I had to get, the lawyer at first wasn't sure they could divulge that. I said, I'm not asking for any violation of confidentiality.
Yeah.
I'm asking simply whether or not the HOA is going to meet and discuss this complaint. And if they meet and confirm, are they going to take action in compliance with governing documents? I don't need to know what action that is.
Nice.
But are they going to do something? Eventually, I got an answer to that because he realized he had to give me that answer.
It was likely yes and yes.
Yes. Well, it better be yes and yes. We'd have a problem. Now, as it turns out, the HOA did communicate with the neighbor. The neighbor communicated with my client. My client agreed to drop the matter if the neighbor paid $7,000. Okay, because there had been some damage. So $7,000, and that covered not only the fees that were incurred in trying to get this to stop, but also the little bit of damage that was caused on a particular scenario in a particular day by one of the cars. But if the person agreed to take the lift out and stop doing that, my client would overlook the fact that there were still cars being stored on the property, et cetera, et cetera. And the HOA was willing to look the other way on that. I told my client, look, if it ever becomes an issue, you can always go to the HOA and demand that they enforce. So for us, he's going to pay your fees and he's going to make you whole. I'd say take that. So they ended up resolving it and the HOA dropped it.
Oh, interesting. Nice.
So that's what ended up happening. It was good news. Bottom line, folks, selective enforcement is actually very, very easy to spot when you know what to look for. As Sam said earlier, sometimes you might not yet have all the evidence, but you have a feeling. You just know something's off. That is, trust your instincts. If you're being treated differently for doing the same thing, or you're being treated differently by being denied something that other people aren't being denied, that is illegal. They cannot do that. And if that does happen, gather your evidence, take care of it as best you can. And if you can't get anywhere with the board after you've presented all that, you come to us at MBK Chapman because we'll set your HOA straight. If you like this episode, please hit the like button. And if you haven't already done so, please subscribe to our channel, HOA Hell. If you'd like to leave a comment or ask a question, please do so. We love reading those. Until next time, have a wonderful day.